Right now, I want to present our friend from Ireland, Mr. Fintan Swanton. Let me just put the presentation. He's the president of the DPO Ireland, member also of CEDPO, and consultant, auditor, and trainer at Signals Consulting.
Okay, good morning, folks. And, okay, now I can. Good morning, everybody. I'm talking to you from Westport in Ireland on our Atlantic coast. Coincidentally, Joe, I was just looking at it online earlier, almost exactly as far west as you in the Atlantic coast in Lisbon, and a little bit further west in Romania. I'm with my company, Signals Consulting, for a number of years now, been providing on an outsourced basis data protection officer services to a range of organizations here in Ireland and also in the United States. And as Marius has just mentioned there, I'm involved in our professional body here, the Association of Data Protection Officers, which is in turn affiliated since 2013 to the Confederation of European Data Protection Organizations, CEDPO. What I want to talk to you about this morning is this requirement under Article 37 for data protection officers to have expert knowledge of data protection law and practices, and the ambiguity of this and the difficulty that exists now and always has exists since the data protection officer role was first created in the 1970s in Germany. We'll look at that in more detail now. The two key words from my point of view on this are the law. You have to understand the law, but you also have to understand the practices. So how do you actually implement this in the course of your day-to-day work? How do you actually conduct a data protection impact assessment? How do you manage the kinds of personal data breaches that we heard about earlier, that mostly are through human error? So take a look at to begin with the background of the data protection officer role. It was first originated under the German Federal Data Protection Act, and Stefan, who's just given us a presentation now, we also had the privilege of having Stefan give us a very interesting and very well received presentation on our data protection conference yesterday morning on the origin and evolution of the data protection officer role in Germany. So that was the very first appearance of the data protection officer role. Just to highlight, it's not unique to European law. So pre-GDPO, 2 years before, for example, under the Privacy Act in New Zealand, they created the role of privacy officer, which still exists under its current Privacy Act, which was updated within the last year or two. The purpose of the data protection, the logic of the data protection officer role under the German Federal Act was to have sort of self-regulation by organizations of their data protection compliance in-house and making it less bureaucratic and not every organization not being under more direct supervision by supervisory authorities. And from the start, the Data Protection Act required that data protection officers have necessary expertise in order to perform these tasks, but it didn't say what that expertise was, and the GDPO still doesn't. I would note that the 1990 amendment of the German Federal Data Protection Act introduced a specific authority for supervisory authorities to demand dismissal of incompetent data protection officers who didn't meet this skill goal, which implies to me that they were either there were actual incompetent DPO'S being appointed, or at least there was a concern that there may be. One of the points that Stefan made to us in his presentation yesterday morning on the DPO role was that there have been occasional orders from German supervisory authorities to data controllers or processors to remove DPOs from the role because of incompetency, but there's very little description in the cases, that the details of the cases that are published as to what the difficulty with incompetencies were. I would just say that I was looking at an article published in the Computer Law and Security Review Journal in 2018, just when the GDPR was coming into effect, and it was saying that the year before, in 2017 in Germany, more than 700,000 data protection officers had been registered. So I presume that the main reason for not having a specific requirement for qualifications is because it was just unfeasible to require a specific certification for that number of people. The German Data Protection Act was a strong influence on the 1995 Data Protection Directive, and among other things in the Data Protection Directive, Article 18 provided for the possible designation of personal data protection officials. This is at the choice of member states whether they introduce this in their national data protection law. For example, here in Ireland, we didn't introduce it. There was no legal definition of a data protection officer before the GDPR came into effect in 2018, but there were quite a few other member states which did. For example, Slovakia, Latvia, France, Hungary, the Netherlands, and quite a few others. Slovakia and Latvia did have mandatory requirements for certification of data protection officers, or these data protection officials, which were operated by their supervisory authorities. And in other countries, like for example, in Luxembourg, it was a requirement for data protection officers, not necessarily to have a data protection specific qualification, but they had to have some third level education in topics like law, information technology, or economics, things like that. So it had already been acknowledged by at least some member states that an official certification standard for data protection officers was a necessity. Think about what are the risks for organizations if their data protection officer doesn't have the necessary expertise to do their job. I think the greatest risk is our main functions as data protection officers are to advise on and monitor the data protection compliance of our organizations. And if we don't have the necessary competencies or skills, the biggest risk is that the organization will be getting poor advice, and this in turn will be creating poor data protection compliance, resulting in adverse impacts on the rights and freedoms of the data subjects whose personal data is being processed by the organizations. And of course, the risk for the organization itself is the risk of potential sanctions and fines, or litigation and legal claims against organizations of the kind that Stefan was just describing in his presentation a few minutes ago, and potential impact on the organization's reputation. I mentioned that the rationale for the DPO role is to strengthen self-regulation, but if there's too many incompetent DPOs, this self-regulation isn't going to work as well as it should, and it's going to create an extra workload for supervisory authorities. In theory, under the GDPR, an infringement of the requirement to designate a data protection officer on the basis of their expert knowledge of data protection law and practices, it could be sanctioned. I think in reality, this requirement is so ambiguous, it's really unenforceable. But in theory, anyway, it's another potential risk against an organisation if it has appointed an incompetent DPO. It could be sanctioned for that in itself. Another more realistic risk that I've actually seen was highlighted by two Irish lawyers, barristers Dennis Kelleher and Karen Murray, who published in 2018 their book on European Union data protection law. And as they pointed out, a controller wishing to dismiss a data protection officer on grounds of incompetence may be met with the allegation that the controller is seeking to impinge on the independence of the data protection officer. And I've actually seen this happen in practice with an organization I was working with. They were based in Germany. I'd strongly emphasize I myself wasn't the data protection officer. But they needed to take their DPO out of the role because of incompetence, and the DPO immediately submitted a complaint against the organization with the local supervisory authority, alleging that this was an infringement of their independence. Not because they were incompetent, because their organization didn't like how they were monitoring and advising on data protection compliance. In the end, that complaint was unsuccessful, but there was a lot of time and effort and resources went into dealing with that complaint. I mentioned the change to the German Federal Data Protection Act in 1990, giving supervisory authorities the power to require the removal from office of incompetent DPOs. We'll take a look now at DPOs in European Union institutions and bodies before the GDPR came into effect. So as I mentioned, for example, here in Ireland, there was no legal definition of the DPO role before 2018 when the GDPR came into effect. But the 2001 data protection regulation, which applied to European institutions and bodies, required that all European Union institutions and bodies should appoint data protection officers. So they were, you could say that European Union institutions and bodies have 17 years more experience on the DPO role than, say, for organizations here in Ireland or in other European countries which didn't apply the data protection official role under the 95 directive. The European Data Protection Supervisor published 10 years after this 2001 regulation came into effect, published a report on the status of DPOs in European Union organizations. And I made a couple of very significant observations. The first was that at that time in 2012, 30% of these DPOs had been in office for 1 year or less. Less than half of them had been in office for more than 2 years. So there was a very high turnover of this DPO role in the EU institutions and bodies. And as the data protection supervisor put it, a key factor causing this high turnover was, and this is a direct quote from the report, a poor understanding of the skills required for the DPO function. So this ambiguity with regard to expert knowledge of data protection law and practices is not a novelty under the GDPR. It was already, as you've seen, a difficulty under the Federal Data Protection Act in Germany and also under this 2001 data protection regulation for EU organizations and bodies. Another observation made by the data protection supervisor was that at that time, 54% of European Union organizations' data protection officers were legal professionals. So what this is also highlighting to me is, and I'll come back to this later, is that although a data protection officer being a legal professional or having a legal qualification may be helpful, it's certainly not a requirement, nor is it sufficient to meet that data protection officer expert knowledge, data protection laws and practices. Around the same time as this 2012 report was published, the network of DPOs of EU institutes and bodies, the professional body for EU institutes, DPOs, had also published a paper on this role. And what it was saying was that although it wasn't a mandatory requirement under the 2001 regulation, it was strongly of the view that data protection officers should have relevant professional certifications. And at that time, 9 years ago, there were fewer specific data protection training programs and certification standards available. We'll get back to that as well shortly. the kind of things they were suggesting were that DPOs should have qualifications and certifications on information systems auditing, information security, and information privacy. Even though it was not a mandatory requirement, the way they put it was that it should be considered an asset by EU institutions and bodies when selecting their data protection officers. I think in Article 37 of the GDPR, it specifically says that the data protection officer can either be an employee of the organization, the controller or the processor, or it can be done by an external entity on the basis of a contract. It can be outsourced. And in its guidance on the DPO role published by the Article 29 Working Party in 2017, which is now being officially endorsed by its successor organisation, the European Data Protection Board, the Working Party's guidance stated that they acknowledged that DPO service contracts could be concluded with an individual or with an organisation. And if it was an outsourced DPO role, then the tasks may be performed by a team of individuals. But the next part of this guidance to me is not, I wouldn't 100% agree with it. It goes on to advise that if you do have an outsourced DPO contract and it is being carried out by a team of individuals, each member of that team, it says, must fulfill all applicable requirements of the GDPR. Basically what it's saying is if you have a football team like this, each member of the team has to have the same level of skills and qualifications. I would disagree with that, and I would 100% agree with the opinion published on this a while back by the Centre for Information Policy Leadership, which said that as long as a team leader holds overall responsibility and accountability for providing this DPO role, the DPO skills, expertise and tasks required by the GDPR can be distributed across the entire DPO team. So you could have a team that includes, for example, an information security specialist and a legal professional, or somebody who's skilled at providing data protection awareness training and things like that. And you can say that that's actually more effective than trying to get everybody in the DPO team to have the exact same level of qualifications and skills. I would highlight just in general, not just with regard to this guidance by the Working Party, but in general with regard to guidance from the Data Protection Board or from national supervisory authorities. It was a comment made several years ago in our annual conference by an assistant data protection commissioner in our own data protection commission, our supervisory authority. He himself is a legal professional. The way he put it was, guidance is guidance, but the GDPR is the law. It's the law that we have to adhere to, not necessarily the guidance. And it's we have to form our own judgment as to guidance and whether we should 100% apply it in whatever situation. One thing I'd also highlight is that I think it would be reasonable for there to be data protection officer certification standards for external organizations providing DPO services for companies. Like I mentioned, I provide on an external basis DPO service, but strictly speaking, it's not me personally that's the DPO of the organizations I'm working with. It's my company, Cygnus Consulting Limited. And the GDPR Article 42 authorization to establish compliance certification standards for controllers and processors could, you could reasonably say, also be applied to firms which are providing DPO services. And I was interested to see in the 2019 Data Protection Regulation of Nigeria, it created an interesting prospect. It said that if an organization is using an outsourced service provider, it has to be a verifiably competent firm or person that's providing that outsourced service. And it goes on then to give authority to Nigeria's supervisory authority to create further regulations on this matter. So the Nigerian supervisory authority could have a certification standard for companies rather than individuals like you or I who are providing DPO services. I'm back to thinking about what the data protection supervisor was saying 9 years ago about the misunderstanding or of what the requirements are for the data protection officer role. I did myself a bit of research on this about 1.5 years ago, looking at recruitment advertisements for data protection officers, mainly on LinkedIn, but for example on Google or Indeed and Monster. And I looked at over 150 recruitment advertisements for DPOs and I was taking a look. What were the expectations of the prospective employers for these data protection officer roles? Again, it's very similar to what we've seen in that report, 2012 report of the European Data Protection Supervisor. About half of these advertisements were saying that they either required or desired their data protection officer to either have a legal qualification or to be a lawyer, even though this is clearly not a GDPR requirement. I was rather surprised that 2/3 of these employers didn't require their data protection officer or desire them to have any data protection specific certification. And even more alarmingly, several of them expressly stated that they didn't mind if their data protection officer, when appointed, had no expertise or competence. Basically, they're saying that they could learn on the job. And that is a clear and obvious infringement of the requirement to designate a data protection officer on the basis of their expert knowledge of data protection law and practices. But the biggest issue I saw, the biggest gap in this is the large majority of these employers, more than 3/4 of them, made no reference to risk management skills. You're probably all aware that risk is a key theme of the GDPR. The word risk is, there's 75 instances of the word risk in the English language text of the GDPR. And specifically with regard to the DPO role, under Article 39, DPOs have a duty to take a risk-oriented approach to the performance of their tasks. But as I said, 3/4 of these employers weren't expecting or asking any of their DPOs to have specific skills on risk assessment and risk management, which I think is critically important for the DPO role. I already mentioned the DPO certification standards, well, the data protection official standards are under the 95 directive. And so, for example, Slovakia and Latvia had mandatory certification standards. Certification standards post GDPR can't be mandatory, but some member states have introduced non-mandatory but official certification standards. 3 main ones that I've looked at are in France, Italy, and Spain. The French and Spanish standards have been developed by their supervisory authorities. The Italian one was developed by the Ente Italiano di Normazione, an Italian organization for voluntary technical standards, and it's actually coincidental that it's this week, the 26th of January, is the 100th anniversary of the establishment of that Ente Italiano. The basis under, as I understood it, French law for the CNIL's certification standard is that under national French data protection law, the CNIL has authority to certify persons, products, data systems, or procedures for recognizing compliance, and it's introduced this standard for certifying data protection officers. As far as I could make out, there's no equivalent specific provision under the Spanish national law, but I assume that the Spanish Data Protection Authority is exercising its task under GDPR Article 57 to promote awareness of organizations' obligations under the GDPR. The Spanish and French standards are quite similar. They have a similar level of competencies. There's quite a little bit of difference in the amount of training they would expect for individuals. The French one, basically, the maximum level of training that you'd have to do is 35 hours, depending on your previous experience. The maximum level of training that you might have to do under the Spanish standard is 180 hours, so it's quite a lot more. Then the competencies in the Italian one, they're quite a lot more extensive. Some of them aren't particularly data protection specific, but they'd be helpful to any professional. Things like analytical and communication skills for any professional, no matter what sector they're in, that would be useful. Others, I think they're a bit irrelevant and will be also very difficult to certify. Things like the Italian organization was saying that data protection officers should have skills of tenacity or stress control. I don't know how you could certify somebody, for example, having stress control. What I would just say is, overall, these three certification standards, they're all pretty reasonable. They're good, high standards, but they are not consistent. And that's a key aspect of the GDPR and other European unions, to have consistent application of the GDPR across all member states. So then I'll take a brief look at some examples, and these are absolutely not exhaustive, but some examples of unofficial certification programs. Stefan there from the GDD mentioned that its organization is the longest established data protection professional body in the world, and it has been providing data protection training for more than 30 years. And if I got it right, since 2005 it's been providing data protection certification standard. Our own organisation, the Association of Data Protection Officers, in collaboration with our parent organisation, the Irish Computer Society, provides, we since 2007 have been providing a certified data protection practitioner program. And then in 2018, we introduced a more advanced certification standard, the European Certified Data Protection Officer program. Our certification standards and training prompt, they're quite similar to the GDDs, not identical, but for example, the level of training, the amount of training is the same. It's 9 days training and covering mainly the same topics, things like their own program, things like managing personal data breaches, conducting data protection impact assessments, understanding data protection by design and by default, and so on. Another example is the law school in Maastricht University in the Netherlands, which has been providing data protection officer certification courses since 2017. Again, like these are official ones that we just talked about. All of these are reasonable. I'd say, because our background, my own professional background is I'm not a legal professional myself, although I now do have a legal qualification. My own professional background is in IT, worked in IT for decades. And the reason why the Irish Computer Society and the Association of Data Protection Officers originally started providing data protection courses was because by default, data protection compliance pre-GDPR tended to land on the desks of IT managers in our country. The Maastricht course is being organised by the law school of the university there, so it's, how to put it, more legalistic than practical than our own, but it's still a good course. Again, they're not entirely consistent, and that's the difficulty. Like, we need a consistent standard for data protection officers. And go back to these, as I said, this is not an exhaustive list. The last time I looked at this, there's more than 50 unofficial data protection training and certification programs available across EU member states. My view on this is that we need a common and official, even though it's not mandatory like those Spanish, Italian and French data protection officer certification standards, the European Data Protection Board could have an official standard, even though it's not a possibility under the GDPR, or at least at the moment, to make it a mandatory requirement. Our supervisory authority, the Data Protection Commission, has published guidance on certification for data protection officers, which is, and it's understandable, it is quite ambiguous because of the ambiguity of the GDPR on this topic itself. But one of the things that commented or said was that if you're getting a certification, ideally it should be an internationally recognized certification. That begs the question, to me anyway, internationally recognized by whom? Our Data Protection Commission didn't say who that internationally recognized it. And in the context of the GDPR, my own view is the only credible international recognition for data protection officer certification would be by the European Data Protection Board. I raised this topic with the Vice Chair of the European Data Protection Board in the first anniversary workshop in Brussels in 2019 for the first anniversary of the GDPR being in effect. The feedback I was getting, not from him, but another European Data Protection Board official, that it would be very difficult, but I still think it should be attempted to get a consensus across all 27 member states for what would be the appropriate standard. But anyway, to finish, I would just say this difficulty with the ambiguity of that expertise for data protection officers, it's not a novelty. It's been there since the 1970s when the data protection officer role was first originated in Germany, and we've seen how in the 1990 German Data Protection Act was already being recognized 31 years ago that incompetent DPO'S were being appointed. And we've already seen, as I said, 19 years ago, in that report from the European Data Protection Supervisor, that there was at that time already a lack of understanding of the necessary skills for data protection officers. Okay, I hope you found this useful. If you have any questions or comments, please pass them on. I'll do my best to answer them to you, Marius. Whether it's now or if you want to drop me a line or by all means give me a call as well. Okay. Thank you for your time.